Hello, welcome. This is the Disability Law Show. Don't you know, John Scholes and James Fireman once again on board, and we're going to be answering your questions today through email and a website called mydisabilityquestions.com. It's free, it's anonymous. Go there and have a look even before we get started here. Then there's always the phone number, 1-855-821-5900. James, how are you, pal? Everything good?
Can't complain, John. Happy to be here.
Coming up here, 3 reasons to avoid long-term disability appeals. I know this is your favorite topic of all time, but before we get to that, James, just before we came on, actually, you and I were chatting a little bit about COVID-19 long haulers. Tell me about it.
So COVID-19 long haulers, if you're not familiar with the term, are the people who had COVID-19, tested positive for it, or perhaps never went to get the test, but contracted it at some point, got over the initial symptoms, but then have had lingering symptoms that have lasted sometimes months on end. Things like extreme fatigue, body pain, often cognitive issues, significant cognitive issues, all of which in combination are going to prevent someone from being able to do most any kind of a job. But the problem is that there isn't a way to diagnose this. Even if you had COVID-19 before, you're not going to continue to test positive for COVID-19 after a few weeks. Even if you have these long hauler conditions, these symptoms that are affecting you down the road. And it creates something of a problem because insurers love to tell people that if they don't have a positive diagnosis, if they don't have objective medical evidence of their underlying condition, then they're not entitled to long-term disability benefits. The problem with that is it isn't true. There's nothing in the policy and there's nothing in the law that says that you require a specific diagnosis in order to be entitled to long-term disability benefits. What you require are symptoms that limit you from a functional perspective to the point where you are unable to do your job. If you have a disability that prevents you from being able to do your occupation, you are entitled to your benefits, whether or not you are able to give it a particular name or find a test that shows objectively that you have it or not. You are certainly entitled to benefits even if you are suffering from what the insurers like to call a subjective issue. So even if that's the case, if you have COVID-19 and you can't point to a specific issue, a specific diagnosis, and your insurer says, well, I'm sorry, we don't provide benefits unless you're able to show us a positive diagnosis, and they deny your claim or cut off your benefits, you have a claim. Do not accept what they are saying at face value. I'm telling you right now, if this is what they've said to you, you should not leave it alone. You should start a legal claim, because here's the thing. These cases have not gone far enough that they've been in front of a judge, and I think it's actually going to be a very long time before that happens. And the reason for that is because as these cases make their way through the system, they're going to start settling very quickly, because the insurers do not want these cases in front of a judge. Because if it goes in front of a judge and the judge renders a decision, that decision is publicly available, and the insurers know that if it goes in front of a judge, they're going to lose. And if there's a publicly available decision that tells the insurers in black and white that they are required to provide benefits to people who are suffering from COVID-19 long hauler symptoms, then that means they're going to have no basis to deny someone in the future that is suffering from those very symptoms. And if they do, they're going to expose themselves to punitive damages, and that's obviously something they want to avoid at all costs.
If you've been fortunate enough to catch our other show, the Employment Law Show here, you'll know that we often talk about a website called pocketemploymentlawyer.ca. I'm mentioning it here on this show, the Disability Law Show, for the fact that there is a section within the pocketemploymentlawyer.ca website that deals with long-term disability. If you didn't know that, again, you can check it out anytime you like. Lots of information on both sides when it comes to employment law and disability law. There's a lot of crossover between the two. It's absolutely free and it's anonymous. So again, check it out at pocketemploymentlawyer.ca. But James, I want to get to our first email of the day, help@disabilityrights.ca. This would be Adnan. Adnan writes in, says, I applied for disability benefits late last year based on physical issues as well as anxiety. While they were considering my claim, I asked my adjuster if she needed my psychologist records, but she told me no, they had enough medical documents already. Last week, they made their decision and denied my claim based on the opinion of their psychiatric medical consultant. Is this fair?
No. Oh, my God. No, this is egregious. This is ridiculous. I mean, you're asking if they want information and they say no, and then they specifically go to that specialty that you were offering to provide and say, well, based on what our guy says, you're not disabled, when obviously your own doctor was telling you otherwise. That is ridiculous. There is absolutely no way, if this went in front of a judge, that they wouldn't be hit with extra contractual damages. That is bad faith. That's textbook bad faith. The process has to be fair. Insurance companies owe a duty of good faith to their insured. And simply what that means is they have to have a fair process. And how can it possibly be fair if they're telling you, no, don't give us this information. We're going to go hire our guy. We're not even going to actually have him see you, but we're going to hire our guy. He's going to just flip through your file. We're going to pay him $1,000 or $2, and then he's going to give us a decision. You think that's not a biased decision? And if it's not weighed against what your treating doctors are saying, how can it possibly be a fair decision? How can it possibly be a fair process? It's just so obviously not. Absolutely, you want to bring a claim here. It is entirely unfair. This isn't a difficult thing for me to advise you on. This is what we call low-hanging fruit. It's a type of case where if you brought a legal claim, I would expect to be hearing from defense counsel within a week or two of issuing the claim, because they know they're done. They know it. And
that term is in that email again, medical consultant. We've had that before. What is that?
So I mean, it doesn't mean anything in particular. It doesn't, you know, there's not a medical consultant's degree. Presumably, it's someone who's not a doctor, because if it was a doctor, I would expect the insurance company to say it was, because obviously that would carry more weight. I expect it's probably someone who has a quasi-medical specialty, someone who might have some experience in treatment, a sub-medical experience in treatment, or possibly even less than that. It could just be someone who is a claims specialist with the insurer who's taken a couple weekend courses. Who knows? Really, until you see what their bio is, you can't tell. And that's certainly something that we do every time we get an insurance file, is we're taking a look at who is making these decisions. Who are the people that the insurers are consulting with? We take a look at their bios, and we want to figure out exactly what expertise the insurance company is relying on.
Coming up, a short break, but after said break, we will get to 3 reasons why you want to avoid an LTD appeal. This is right in James' wheelhouse. It's his favorite topic ever. We'll get to that. 1-855-821-5900 and help@disabilityrights.ca is the email address. This is the Disability Law Show. There is more coming up.
People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Disability Law Show. John Scholes along with James Fireman. To reach out, 1-855-821-5900. We put that up on the screen all the time. And the email address is help@disabilityrights.ca. So you want to send an email along, we'll get it either on this or a future show. Don't hold back. We'd love to hear from you anytime. Okay, James, 3 reasons to avoid the long-term disability appeal. We love this topic. So we'll get to our first one, and that is an appeal through the insurance company rarely works. Really?
I feel like this is, you know, a reunion tour, and rather than playing my new album, I'm just going with the greatest hits. This is right in the wheelhouse there. So let's talk about the appeal process. Yep. If you apply for long-term disability benefits and your claim is denied, or even if it's initially approved and then cut off, you're going to receive a letter from your insurance company, and it's going to be telling you that they've denied your claim. Sometimes it'll give you an explanation why. Oftentimes that's going to be very vague. And so you're realizing all of a sudden that this safety net that you've been relying on to be there is not going to be there, even though your doctors are telling you that you are not medically fit to go back to work. and you're thinking, well, this is incredibly unfair, this isn't right, but what can I do about it? And then you read down in the letter, and towards the bottom, there's this section on appeals. And you think, oh, well, there it is. There's the solution right there, as though the appeal was a process handed down from God. Let me tell you, it is not. So the appeal process, you might think that it means that your case is going to go to some independent arbitrator or judge somewhere that's going to determine whether or not you have a valid claim. It is not. It's going to go back in almost all cases to the very same person, or perhaps the supervisor of the person that made the decision in the first place. And because of that, it's very unlikely that they're going to change their mind. You have to think about the motivations that are involved in this process. So an insurance company is a corporation. Corporations have shareholders, and they're required to do what they can to make profits for those shareholders. That's fine. I don't begrudge them that. But consider what the motivation is from the insurance company's perspective. In order to make a profit, the only way they can do that is by paying out less benefits. And so that means they have the justification, or they have an objective, to try and cut off or deny claims as often as possible. And once they found a justification to do that, it's going to be incredibly difficult to get them to change their mind. Short of information that completely changes the nature of why you are disabled, your insurance company is virtually never going to listen to your appeal. They're never going to give you the approval that you think that they might. It is false hope.
Is it the sound of it, an appeal, like it's going to go to some appellate court, so therefore it's an official thing, it's out of the hands of the insurance company, so maybe I have a shot at this one? Plus, I mean, is this just going to happen once? Can it happen more than once, 2, 3 times?
I suspect the name itself just connotes a particular amount of objectivity that simply isn't there.
Right.
When you look in your policy, if you want to take a look at what the appeal process is, if you go to your policy, you're not going to find anything there. There's nothing in your policy that describes the appeal process at all. There's no legislation that talks about the appeal process. It is a process that your insurance company has entirely made up. And they make it up because they want you to appeal. And so if you appeal once and you're denied, you're absolutely right, John. They're gonna offer you the opportunity, and I should say opportunity, to appeal as many times as you want in most cases. I've had clients come to me that have literally appealed 7 times before finally deciding to bring a legal claim, and every time they were denied. And in this one particular case I'm thinking of, after having 7 appeals denied and starting the legal claim, they paid virtually the entire amount remaining under the policy because he was simply entitled to it.
It's amazing. It sounds like they're designed just to keep the power in the hands of the insurance company, right?
Well, that's exactly what it is. So when you appeal, there's nothing that requires the insurance company to follow any particular process. Again, it isn't written down anywhere. They're making it up as they go along. And you juxtapose that, you put that, compare that with what happens when you bring a legal claim. Well, all of a sudden, the insurer realizes in a legal claim that if they're not reasonable, at the end of the day, they wind up in court in front of a judge, and they want no part of that. They don't want to be anywhere near a courthouse. They don't want written decisions that talk about all the ways their process is unfair. So as soon as you start a legal claim, as opposed to an appeal, all of a sudden the insurer has a significant motivation to become reasonable, because they know financially it's much worse for them if they wind up in court. It's much, much worse for them. Whereas if you bring an appeal, there's really no motivation for them. There's nothing that is lighting a fire under their butt that's making them come to the table and be reasonable until you bring that legal claim.
Is part of the reason because once you make a legal claim, it's now out of the claims adjuster, it goes to their legal team?
Yeah, that's entirely correct. So there are different departments in insurance companies. It shouldn't surprise anybody that insurance companies are bureaucracies. And so when you apply for benefits, it goes to a claims department. And that claims department is separate from the other departments, and they have their objective. Their objective is to try and deny claims as quickly as they can or cut them off when they've been approved. And they have claims handlers that are handling each of the files, and each one of them at the end of the day is judged on how effectively they meet that objective. When you bring a legal claim, when you challenge a denial in a legal claim, then all of a sudden it gets taken from the claims department at the insurance company over to the legal department. And the legal department has a very different objective. The legal department understands what's at stake once you've brought a legal claim. They know that it winds up in court in front of a judge if they are not reasonable. And so their objective is to minimize the damage. It's a different objective than in the claims department. And because of that, they do act reasonably. It's an excellent point, John.
The third point is that you can miss the deadline to start a legal claim for compensation. How does that work?
Well, this is something you got to be very careful of. So there are different deadlines involved in the long-term disability claims process. The first deadline is about application, about applying for your benefits after you become disabled. Typically, we see a 90-day deadline. But if you miss that deadline, it is almost always going to be the case, as long as you haven't missed it by years, it's almost always going to be the case that the insurer is ultimately going to be required to consider your application. If they deny your application on the basis that you've missed the application deadline, then typically if you brought it before a judge, the judge is going to provide what's called relief from forfeiture, which simply means the insurance company is told that they actually have to consider the application as they would any other. But that's only at the start. Once they've denied your claim or cut off your benefits, once they send you that letter that I was talking about a couple of minutes ago that says they've denied your claim or cut off your benefits, the clock starts running on a limitation to bring a legal claim. You have 2 years from the date that that denial or termination letter is sent to you in order to bring that legal claim. And it really doesn't matter if you appeal once, twice, 7 times. The clock is running from the first date that they send that letter. And if 2 years elapses from the date they send the letter until you first bring your legal claim, then you're going to be barred by statute. The law says that if you don't bring your claim within 2 years, you're out of luck. And that's what they're hoping for. They're hoping to drag out the process as long as possible so that either you get so frustrated that you just give up, or you spend the 2 years trying to appeal, and then all of a sudden you're out of time and they say, well, sorry, we don't have to deal with you anymore. There's no way that you could bring this in front of a judge, and so we don't have to deal with your claim at all.
Seems like the moral of the story is just start a legal claim, which, in some ways it seems a little counterintuitive because, if I'm the person that's been denied and I've been asked to appeal, you're saying, oh, bring lawyers involved, get your law firm involved. But is it not the case that if you start a legal claim, as you said, it goes from the claims to the legal department? Now you're dealing with people who speak your language, the lawyers on the other side of the table. So things should wrap up quicker because, as you said, they know what's at stake. They're lawyers, right?
Yeah, we make a habit at our firm of bringing claims as quickly as we can.
Right.
Now, we're not going to do it until we're convinced that there's a case there, but as soon as you know that there is a valid legal claim there is no benefit to waiting. The longer you wait, the longer it's going to take for resolution. And we are almost always resolving our cases in less than a year. Oftentimes, it's within a few months. And so, yeah, you want to get it started as quickly as possible for sure. There's no benefit to waiting. And if you've been denied, you want to give us a call and find out whether or not you actually do have a claim.
All right, let's take a short pause. We got more coming up here. When you are deemed not totally disabled due to a mental health condition, we'll tackle that after we take a short break. 1-855-821-5900, the number to reach out, and the email address as well, help@disabilityrights.ca. This is the Disability Law Show. There's more on the way.
People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, back at it. Let's keep going. Disability Law Show. James Fireman is there ready to answer some more questions. The number anytime, 1-855-821-5900. Also another wonderful resource for you, absolutely free and anonymous, mydisabilityquestions.com. There you type in your questions to James and his crew. You can also search the database of previously asked questions, which is nice because it'll save you some time. If your question or one similar doesn't come up, that's okay. Leave yours there, and it will be answered by a member of the team for sure. So we'll get to one, James. This from Rachel. Rachel writes in, says, my cousin received a denial letter in the mail from his long-term disability insurer that said they don't consider him totally disabled. He's been off work for over a year because of severe depression and hallucinations as a result of being the victim of a violent crime outside his apartment. His doctors have all said that he is unable to work and he takes numerous medications. Is there anything you can do to help?
Yeah, I'm quite sure that there is in this case, Rachel, and thank you for writing in on behalf of your cousin. If you have a friend or a loved one who is applying or in the process of applying for long-term disability benefits or has been denied and you think it's unfair, by all means, feel free to reach out on their behalf and get some information. It is completely free. You don't have to reveal any sensitive information. We're more than happy to talk to you. It's a 100% free consultation, or you can write in and we're happy to answer your questions on the show. So let's talk about your particular question, Rachel. And there's a phrase in your email that I want to narrow in on here, and that phrase is totally disabled. And that's a phrase that is used by long-term disability insurers pretty much across the board. And it's used for a very particular purpose. Now, if you were to say that someone was totally disabled in your day-to-day conversations with friends or family members, it has a very particular meaning. If you said that, you have a friend who's totally disabled, someone would think that you're talking about someone who really can't get out of bed, who can't do things for themselves, can't bathe themselves or make their own food or dress themselves. That is what most people think of when you use the phrase totally disabled. When we're talking about disability law, it means something very different. It has a very narrow meaning, and that meaning is defined in the policy. You have to look at your insurance policy, and there's going to be a definitions page, and it's going to set out exactly what totally disabled means. And all it means is that you have a disability that is preventing you from being able to do your own occupation during the first 2 years and then any occupation thereafter. It is only about how the disability prevents you from being able to work. And so, it is a very misleading phrase, and frankly, it's done quite intentionally. It's done exactly to confuse people, because when you get a letter from your insurance company and it says, well, we found that based on the medical records, you're not totally disabled, a lot of people are going to read that and say, I guess that's true. I'm not totally disabled. I mean, I can do some things. I can't work, but there are still some things I can do, so I guess I'm not totally disabled. And there are a lot of people that, because of that, are not going to challenge their insurance company when they really should. If the insurer had any intention of being fair or of not misleading their claimants, they would call it something else. They would call it disabled from work. That is a far more descriptive term of what we're talking about. But they don't. They use a phrase that's intentionally misleading. So please do not be fooled by that if your insurance company has told you that you are not totally disabled when your doctors are telling you that you can't work. If your doctors are telling you that you can't work, you ought to be entitled to your benefits. And so getting to Rachel's question here about her cousin, it sounds as though his doctors are telling him that he is in fact disabled from work, and it sounds like a very horrific situation. And I obviously feel very badly that anyone would ever have to go through this, and it's fairly incredible that the insurance company would be rejecting a claim like this, especially when all of his doctors are telling him that he's not able to go back to work. So yeah, that is absolutely the exact type of claim that we can help with. We start a legal claim. Again, you move it from the claims department to the legal department, and all of a sudden you have an insurance company that's willing to act a lot more reasonably.
Let's get to an email, James. Again, it is help@disabilityrights.ca. We still got some time. This is Mark, writes in, says, what happens if I am fired while on long-term disability? Would my benefits continue through the insurance company? My boss may be letting me go because I haven't been able to work for the past 6 months.
So, Mark, very good question, and it's something that we get asked from time to time. And so what you need to understand is that if you have insurance coverage, long-term disability insurance coverage, on the date that you become disabled from working, then you are entitled to continue to receive benefits as long as you remain continuously disabled from work up until you're 65. So to use Mark's case as an example, Mark had disability coverage at the time he became disabled. In fact, as I understand it, he is in fact getting long-term disability benefits now. His concern is that he may well be let go from his job at some point in the near future. And so he wants to know if he's going to be able to continue to get benefits. So Mark's claim, his disability, arose while he certainly had disability coverage. Therefore, as long as Mark remains continuously disabled from working, he will be entitled to continue to receive benefits whether or not he remains technically employed through his employer. It makes no difference whatsoever. And so as long as he's continuously disabled, even if it goes all the way up to 65, he continues to receive those benefits. If he can show that he has a disability that whether or not he's got employment is still preventing him from being able to work, then he's entitled to those benefits.
I think we got time for one more shot at mydisabilityquestions.com. James, let's tackle this one from Elaine. Says, I was on short-term disability for 6 months, but when I applied for LTD, they denied me. I suffer from seizures and a degenerative neurological condition that was just recently diagnosed. My LTD insurer is the same insurer that paid my short-term, my STD, and my doctor confirmed that I cannot work. I appealed, and I was denied. Can you help me?
Yeah, we absolutely can help in this type of situation. So, first of all, there's an obligation to pay LTD benefits right up to age 65. But what I find really interesting here, though, is that we're talking about the same insurance company. There was the same insurance company that decided that Elaine was entitled to benefits, so therefore met the definition of totally disabled during the short-term disability period, the first usually 6 months. But then when she applied for long-term disability benefits, all of a sudden the insurance company is saying that she's no longer entitled to those benefits. Well, it seems pretty convenient to me that on the day that she becomes entitled to long-term disability benefits, all of a sudden the insurance company is of the view that she no longer meets the definition of totally disabled. Now, I suppose it's possible that the definition of totally disabled under the short-term policy and the long-term policy could be different. Oftentimes, a word here or there might be different, but in substance, they are virtually always going to be the same. The only real exception to that is if there was a pre-existing condition. We do see situations where there are pre-existing conditions that the insurer could rely on to deny long-term disability benefits, but that would not be something that they could use to exclude short-term disability benefits. In those situations, it can make sense that the long-term disability benefits are denied. But when you have the same insurance company insuring for both short and long-term disability benefits, and there's no pre-existing condition that the insurance company is relying on, then it really is difficult to understand a situation where all of a sudden the insurance company is changing their mind. I mean, what's really happening here is the insurance company is looking at the maximum pay date, that this person is going to be entitled to benefits up until age 65, and they see that as being enormous exposure. I mean, I'm not sure how old Elaine is, but if she's, let's say, in her 30s, then you're talking about 25, 30, 35 years worth of benefits there. Wow. And that adds up real quickly. And you better believe insurance companies have a big incentive in those situations to find a justification to cut off benefits. And it may not be a particularly good one, and it doesn't sound like it is in this case. So more than likely, the insurance company is looking at it and saying, you know what, let's just take a shot because most people aren't going to challenge our decision, and so we'll see what happens. And so Elaine has reached out. We can start a legal claim and bring the insurance company to the table and make sure that you get what you're reasonably entitled to.
And she appealed. We don't want to do that over again.
Yeah, I've already spent quite a bit of time talking about it, but it's worth repeating, John.
Yep.
Don't appeal. It is a waste of your time. Start the legal claim, take control away from the insurance company, and make sure that they have to come to the table and act reasonably.
Covered lots today on the show. James, any final words before we wrap up?
No, listen, really, it is worth repeating always, don't appeal. And I've said that now maybe 5, 6 times during the show. And I think it's also worth reiterating what I started with off the top. If you have a COVID-19 long hauler condition, if you are suffering from symptoms long after you are no longer testing positive for COVID-19, and your insurance company is telling you that you're not entitled to benefits because you can't show them a diagnosis, they're wrong. Give us a call. Let's start a legal claim and make sure you get the benefits you're entitled to.
That is all. 1-855-821-5900 is the way. That website, mydisabilityquestions.com, is for you anytime you want to ask your questions. Leave it there. James or a member of his team We'll get to it, and we always rely on the old email as well, help@disabilityrights.ca. Simply just disabilityrights.ca. We'll give you links to our radio shows as well, by the way. We'll catch you next time on the Disability Law Show.